Our work, and this is really the prerogative of the Commission, is the work with the member states. Here, as you know, the regulation provides for the possibility for the member states to further specify the application of the regulation on the national level. I would like to underline the word further specify. So the regulation is a regulation. It's a directly applicable law throughout the EU. It fully harmonizes the application of data protection rules in the EU. We do not want to go back to 28, 27 national data protection rules, what we de facto have now in Europe. And therefore, it means something also for what the member states can do and how they can use the space they have while further specifying national rules in specific sectors, in the areas in which the regulation gives them this possibility. So we entered into a dialogue. We provided for something very unique as far as the regulation is concerned, namely for an expert group, working group, with representatives of the member states, ministries, people who now draft and consult you on their drafts of the specification laws. And there we offer a forum for exchange, communication with the Commission and with other member states about the possibilities, the challenges the member states have, while further specifying the application of the GDPR rules on the national level. So the first message which we are really sending to the member states is that the national laws, the first exercise, before even engaging in all this further specification of the GDPR rules in specific sectors, what needs to be done is to adopt and repeal, as necessary, existing data protection rules on the level of the member states. The main theme of these discussions with the member states and dialogues, bilateral or within this expert group with the member states, is harmonization and simplification of data protection rules and consistent and high level of personal data protection across the EU. Again, these new measures cannot lead to reopening of the harmonization provided for in the regulation. The regulation is based on Article 16.2 of the treaty. Article 16.2 of the treaty pursues two objectives. One is obviously high level of protection for personal data, but the second element is free flow of data within the EU. And this cannot be lost of sight, as member states should not lose it out of sight, while providing for the specification and solutions which are obviously necessary in such a, when one deals with such a horizontal legislation. So just to give you a flavor a little bit of what is being discussed, for example, the questions of the reach of this national specification laws when once adopted on the national level. What do I mean there? It's actually a question of international private law. If a member state X adopts laws further specifying, for example, using the genetic data for the purposes of insurance, so using the scope provided for further specification under Article 9.4 of the GDPR, what is the reach of this law? Does it mean that an organization from the member state Epsilon, while offering services on the territory of this member state X, will need to comply with these laws? Or can it comply, or is it enough when it complies with the laws where it is established, namely of the member state Epsilon? So here are very interesting issues going beyond data protection questions, issues which are also very important for data protection authorities, because depending on which point of attachment, establishment, or residence will be then used by the member states, it can mean that data protection authorities will sometimes need to apply a law of a different member state. But again, this is one more reason so as to incentivize everybody to not to abuse of the possibility to further specify the laws on the national level. And here, again, the GDPR provides only in very few instances for the obligation for the member states to legislate. In one area, obviously, is data protection authorities. Another one is to provide for the means for administrative procedure, which are obviously necessary in order to enforce the rights given by the regulation. Another, it's Article 85 of the regulation, where the necessity to find a balance between freedom of expression, freedom of journalistic, artistic, literary expression needs to be reconciled with the data protection rules. So these are just the few areas, in the moments, to put it in a way, in the regulation where the national states need to do something.